Welcome, everybody. My name is Marty Mascari, and I'm with the North Central Texas Area Agency on Aging and the North Central Texas Aging and Disability Resource Center, or ADRC, both of which are under the North Central Texas Council of Governments in the greater Dallas-Fort Worth, Texas area. And I have to say that because we end up with lots of people on that are from all over the country at this point, and even some international people. So we're in the greater Dallas-Fort Worth, Texas area, and we are blessed once again to have our partners at Heyman Hogue here to talk about executor versus trustee, the differences and what to expect. But before we get started, we'd like to go over the information about the CEUs for those of you that are looking for certificates of attendance or CEUs. And I'm going to let Sheila do that.
Good morning, everyone. Yes, I am Sheila Williamson, the Director of Community Services with Heyman Hogue. We're so glad to be a part of this, and we're so glad that you could join us because, like I said earlier, an educated public is better for all of us. We're here to offer you CEUs today, and here's how it works. It's very simple. Okay, there's two forms, and I know you're all used to doing CEUs. There's two forms that I will need returned. There's three that you will receive, but there are two that I need returned. One is an eval form about your evaluation of this webinar, and the other one, and at the very bottom, it does ask if you have any suggestions for future programs. I'd love it if you fill that out. We do listen to those, and we're doing the next one because of that. Then also the other one is a sign-in, basic sign-in. The last one that you'll receive is a disclaimer because we do this for a living, but we're not selling anything today. All we're doing is educating you. Just want you to know that we certainly do this for a living, but we're here to educate you so that you can help your people and perhaps yourself. So that's it.
Once you get those forms and complete them, please send them back to Sheila. Her email address is here, and it will also be, you'll receive those forms in a follow-up email from me. In addition to that, we have a Google survey that we asked you to complete that helps us collect the information that we need to report back on the goals and objectives we set forth when we applied for the funding to do these webinars. So that should pop up or give you a chance to go to that as you close out of Zoom today. If not, that link will also be in the email that I send out, the follow-up email. So please help us with that if you would. Sheila, I'm gonna ask you if you'll introduce Rex and Susan and we'll get rolling.
I certainly can. I'm so proud to have today two of our partners, which you don't ever see us doing that, but two of our partners are on here today because this is really important. And we chose this topic because of a story that we got actually from a TV producer who got thrown into this world, not knowing anything about it, that someone had named her as an executor, and she didn't know anything about that until they called her. The lawyer called her, and she's like, what? So we decided that this might be a good time to do this, to explain the duties and the roles. There's no better people to do that than Susan and Rex because they are partners in the firm, yes, but they also have a tremendous experience doing this. So Susan Barnett is the head of our probate and trust administration team. Perfect person to do that. And Rex is one of the founding partners of the firm and is the guru for all of our trusts. So between the two of them, they have many years of experience. There's probably nothing that you can ask them that they cannot answer. And I will be monitoring the questions and we will answer them at the end.
Sheila, you got to stop with the challenges.
I am fully, I know that you can do it. So anyway, no further ado, here are Susan Barnett and Rex Hogue.
One thing I do want to remind everybody that Rex said earlier, Rex has to leave about 15 minutes early to get on another webinar. So if you have questions about trust that you really want to get answered, please get those in as quickly as possible. We want to try to get those answered before he has to leave at a quarter after.
And I'll stick around and field whatever is still going on, but good idea to get those questions in early. So, okay.
I was kind of kidding when I said that. Susan can answer them too.
Okay, so my name is Susan Barnett. I'm really glad to be with you guys today. Today, we're going to talk about executors versus trustees and what's the difference. And it's a very common question that we get that people it's actually not even a question. They interchangeably use the terms. And so you guys are going to walk away from this probably never wanting to do that again. But it is a very common thing. So we'll talk about as we go on today. We're going to start out with fiduciaries, and we're going to talk about what is a fiduciary and what their duties are. We're going to talk about fiduciaries and their roles while you're alive, but maybe incapacitated. There's agent versus trustee. There's guardian versus trustee, and there's executor. And then after death, there's executor or administrator versus trustee. So we're going to talk about those fiduciaries and what their different roles and responsibilities are, so that when you finish here today, you will definitely know the difference.
So what is a fiduciary? Well, it's a person or organization to whom property or power is entrusted for the benefit of another person. And it's important that you understand they do this for someone else's benefit. The duties are identifiable and must be followed. Now, we have a workshop, a trustee workshop, and I pulled some slides from there and did not change them because these rules apply to all fiduciaries. They owe a duty of good faith and trust to whoever that beneficiary is. They have to act in the best interest of that other person. They must put the interests of that other person before the fiduciary's interest. And that is one of the biggest problem areas for fiduciaries. They have to avoid self-dealing with that person to whom the duty is owed, and they must avoid conflicts of interest with that person. Fiduciary is the highest duty that one person owes another under U.S. law. And many times we have to remind fiduciaries of that their duty, they have to put their own interests aside for the benefit of someone else. Now, fiduciaries, if they're ever sued, we're going to start with what are their lines of defense. Now, this says follow the trust terms, but that means also the terms of the will, perhaps the power of attorney as well. They have to do what it actually says, not what they think was intended or what the fiduciary wants to do. You can't be selective in what you carry out. You have to follow the terms, and if it says there's 3 beneficiaries, you can't benefit one of them and not the others. The second line of defense is how you carry out the terms. Once you accept the job, you can't get out of problems by resigning. Had that come up in a case one time. CPA was the trustee and he was only benefiting one person, and when it was brought to his attention, he just resigned and discovered you can resign, but you can't quit until there's a replacement. You will have to provide a final accounting. Sometimes that gets waived, especially if there's no real questions. But if there's any questions, you're going to have to provide that final accounting. The 2 most common reasons for a trustee to be sued, and really this is any fiduciary, self-dealing and breach of fiduciary duty. Juries, by the way, are very hard on people who do either one of those things. The third line of defense is how you protect the information and assets. So when you're a fiduciary for someone else, it's important that you protect information and you protect assets. If you're the trustee, for example, after death, you may have to go to the house and make sure that the wild child isn't in there taking all the goodies. You've got to protect against that. Keep good records. It's amazing to me how many fiduciaries will throw away records and then expect even to be paid on them. Proper computer backups and strong passwords. That's important. We live in an electronic world, and if you don't know how to go create those things, get help doing it. Learn what options might be available that you need to exercise. Don't take a wild guess. Talk to somebody who would know. Have a plan for someone else to have access if something happens to you. You become incapacitated, that can be a breach of fiduciary duty. If somebody is just stuck and they can't do anything and they have to go get a court order. Plan your affairs since you are still responsible. A lot of fiduciaries wind up doing estate planning when they realize, hey, they need to do this for themselves as well. Now, I'm going to talk about powers of attorney, and we're talking here about dealing with incapacity. There's really 3 ways to do it. In a power of attorney, a principal gives the agent a power of attorney. It's an invitation to third parties to let the agent act on the principal's behalf. What are the 2 things you can do with an invitation? You can accept it or you can reject it. And it's important that you understand that's the third party's option. You can't force them to accept it. If they don't accept it, the question is, what's the next plan? Well, one possible plan B, if you will, is guardianship. It's defined as the court-supervised management of assets for somebody who's legally incompetent. It's sometimes called living probate, and Susan's going to tell us quite a bit about that today. The other alternative is a living trust. It can replace powers of attorney. It provides the necessary substitute signature that Susan will talk about. It avoids guardianship and probate up to the extent that assets are in the trust. And it can even provide instructions for the incapacitated trust maker's care. An institution's job is to protect the principal's money. So let's, for the moment, assume that I take a power of attorney for Susan to the bank, Susan's bank. They know Susan, they don't know me. Their job is to protect her money. So she's not at that institution to tell them it's okay to take that power of attorney. The institution cannot know any of the following things. Is she still alive? If she's not, that power of attorney died when she did. If they give me money after she dies, based on my authority as an agent, they're going to have to replace that money unless they can talk me into it. That is not how banks make money. They don't know if the principal might have revoked that power of attorney. They don't know if the principal is really incapacitated. Now think about the problems that creates for them. Before they give me money, they're taking a chance that none of these are issues. They don't know if fraud, duress, or forgery was involved in the creation of the power of attorney. I actually had somebody sign a power of attorney one time when he believed he was signing permission for his kid to play soccer. I mean, those are not at all related to each other, but that's really what he believed. In any of these cases, the institution is liable to the principal. And if you understand that, you will understand why institutions so often reject powers of attorney. In fact, in my experience, they are at least as likely to not accept it as they are to accept it, maybe more likely. And these are not the only reasons that powers of attorney fail, but if you understand the significance of these 3, then it'll make sense. And I listed 4 up there. Now, when they fail, what is plan B? Well, there's 2 choices, but let's start. An individual owns assets or any form of joint ownership. One becomes incapacitated. We go to the probate court, and there's a guardianship possibly of the estate, which can be very difficult, and a guardianship of the person, which is easier. Now, guardianship is a solution to a problem. The problem is a person is unable to sign necessary documents to manage assets. So we have guardianship for one reason. We need a substitute signature. And in guardianship, that's what the judge does. He authorizes, or she authorizes, a substitute signature. Guardianship is frequently and frequently the only solution to the problem. Susan, is guardianship the best solution to the problem?
Not at all. Guardianship is a really tough process on everybody. First of all, it takes a lot of time. And if you've got an urgent situation, a guardianship is not generally going to give you a quick answer because you're depending on the courts and others to push that through. It is extremely expensive. It starts out base. You have to have 2 attorneys involved because you've got the attorney that represents the applicant wanting to become the guardian, and then the court has to turn right around. By law, he or she is required to appoint what's called an attorney ad litem to represent the proposed ward to make sure that they're not being taken advantage of. Sometimes even a guardian ad litem is added. There's doctors involved, social study, all those things cost money. There's potentially a lot of going to court. Sometimes if there's not an objection to the guardianship, maybe there's only one trip, but that is not always the case. It may take multiple hearings, and remember, there's at least 2 lawyers involved, so you can imagine how that goes. And then once the guardianship is granted, it's really a complete loss of control because the court then has control over everything. Now, as Rex mentioned, there's guardianship of the person, which is less invasive. It involves an annual report by the guardian once a year, just letting the court know how the person is doing. But if you're talking about guardian of the estate, where there are assets to be managed by the guardian cannot spend 1 dime, even on the ward, without court permission. And every time you go to court, you've got to have at least the applicant's attorney involved to make that application for spending money. So it's very invasive in that way. Loss of dignity is one of the things that's really hard on families. You are bringing someone into court that you love and having them declared incapacitated. And it is not uncommon, especially in this day and time with the condition, the mental decline of our elderly population, for the person who is the proposed ward to oppose it and think that they're fine. And it can be extremely humiliating for them to have to go through that process, not to mention the pain it causes the family. There's also a major problem with protecting the assets of the proposed ward because it does open the door for creditors and predators to come in, and a door that doesn't have to be opened. We're going to talk a little bit about a case study just to give you guys an example of how this works. So we've got Carl and Myra here, and their kids are Peter, Paul, and Mary. I can't take credit for the creativity, that's Rex's. But Myra had passed after a long battle with cancer, and Carl has Alzheimer's. They've tried to use his powers of attorney, the powers of attorney that he has, but they have failed. Banks have refused to use them. They have a $500,000 home. They have $500,000 in IRAs, $1.8 million in investment accounts, and $200,000 in bank accounts. And like I mentioned, the old POAs that he had aren't valid. So what is needed? They're needing to get access to assets in order to provide for Carl's safety and well-being and health. They need to sell the house because it's no longer feasible for him to live there. They need funds for Carl to be able to be in a facility in a safe place. They started this process a year ago trying to make these things happen, and they've been struggling with it. So now we're looking at, truly applying for the guardianship and the steps in that guardianship. They're going to have to get a doctor's report for Carl. It's called a certified medical exam. And then they're going to have to hire an attorney to file the guardianship application. Oftentimes it is that attorney that will let them know about the CME that needs to come from the doctor. And they're wanting to propose Peter as the financial guardian of the estate. They're going to have to send notice to all of the interested parties. In this situation, it would be all of his adult children. The judge is going to have to appoint an attorney ad litem, as I mentioned, to represent Carl. Then there's going to be no access to financial information or assets until the guardianship is complete. They do have some information because they've got the statements that have been coming to the house, but they can't, the bank won't talk to them. They're not going to be able to access that information easily. There's going to be a court investigator that is going to do a background check on Peter. But as is often the case, the courts are backlogged and those on background checks. And so that takes a while to get it done. Peter has to qualify for a bond. When we're talking about an estate, guardianship of an estate, the guardian has to have a bond to cover the value of the assets. And the bond generally can cost up to 3% of the value of the assets. In this case, that would be around $90,000. And if he can't qualify, he's going to have to put up the bond himself, which would be nearly impossible. So when he spends this money on the bond, there's a possibility after Carl dies that he could be repaid in probate, but we don't know when that's going to happen or what that's going to look like and what the estate's going to look like at that point, because that's where that payment would come from. And then once he's gone through all of this, the last thing he's got to do is go through some approved training as guardian and get certified to be able to serve as guardian of his own father. So there's 12 steps that have to be put in place, and things that you need to consider and know about guardianship. First of all, when you've got a high net worth guardianship like this, the minimal cost you're going to look at is $40,000 or more. I mean, there's just really not an upward limit. If there's creditors and predators involved, it's going to cost more. Annually, there's going to have to be an accounting of all that's been spent out of Carl's estate, his living estate. And that is a very expensive process as well. Also, there's a constant stream of things that happen as long as that ward is alive, whether they need increased care, a fall, going to the hospital. It's a never-ending stream of surprises and issues that come up that create new duties to take care of. And then it's if he did have a good estate, business, or asset protection plan, having a guardianship can blow it all out of the water.
Well, there is a better plan A. We go back and look at the issue is incapacity. The alternative to guardianship is having a trust. And if you have a trust that owns the assets, that trust can replace powers of attorney. It avoids the guardianship. It's private. It can have incapacity instructions. The successor trustee manages it. It's easy to manage, change, and update, but it works best when assets are fully aligned with the trust. If you have multiple business owners, people don't think about this. Your business partner becomes incapacitated. You may suddenly have the court controlling your business. And then do business owner estate plans adequately cover incapacity and divorce? I've had the misfortune of having two business partners go through divorce. It's not a lot of fun, not even for the partners. Now, what is a trust? It's a contract that involves three parties, the trust maker, and they go by other names. The trust maker makes up the rules of the game. The trustee manages the trust, and their job is to manage the trust according to the terms the trust maker set up for the benefit of the beneficiary, the third party to that contract. Now, in most revocable trusts, in this case, Carl and Myra, they could have set up a trust, been the trust makers, named themselves as trustees, and been the beneficiaries. That's the typical arrangement in a revocable trust. The trustee holds assets for the trust. It's often stated as the trust owns the assets. I won't get into the technical differences, but trusts that are in the trust avoid guardianship and probate. Well, we're now going to look at Carl and Myra's case as though they did a trust 3 years ago, right after Myra was diagnosed. Carl was not yet showing signs of Alzheimer's. So how's that trust going to work, assuming they get the assets transferred property? Well, not all trusts are the same, but in this case, it worked well. Myra felt it would be best if Carl served with Mary. However, Carl preferred Peter. They came up with a compromise. Carl would serve with Peter, Paul, and Mary, and Carl would have 40% of the vote. So Carl would have some measure of control. He only has to have one kid agree with him. He can't be outvoted, with only 2 of them. When Mary needed a facility, and I'm talking about the daughter, the trust provided suitability instructions. I'm sorry, that should be Myra. The 2 facilities fit the criteria. Both were within 20 minutes of their home. So Mary picked a place closest to her because she had the time and she lived closest to them. And that's very common. Peter lives further away, but he's maybe better at managing the money. So the kids can work together. Now, once Myra's in the facility, the kids took care of the bills. Carl could spend time with Myra, and Mary realized that Carl could not stay at home. The kids serve as the incapacity panel. They could sign a sworn statement that Carl is incapacitated and remove him as a trustee if that's necessary, but it may not be necessary. Third parties have become used to dealing with the kids. The kids are trustees. Trustees hold legal title to the assets. So they don't have any issues dealing with a trustee like they do with an agent. A trustee will always have way more authority than an agent ever will. They can move Carl to a facility without a doctor's statement. And the trust instructed them to use the same facility for both and even put them in the same room if possible. Now, not every trust does that. And I can tell you that that can be a problem if it doesn't have instructions like that in there. Don't think you're going to buy the cheapest trust out there and get these kinds of instructions. Also, in 2020, having the trust avoided an unnecessary RMD because they were waived that year, but they didn't have any authority to waive it without a trust being in place. So there's been no fuss or issues with any third parties to handle things this way. The assets under control by the trust do avoid probate. It's a qualifying trust for homestead protection. Now, not every trust is. And if you have a trust from out of state, the chances of that trust being a qualifying trust under Texas law are about halfway between 0 and none. We have people who move from other states and they come in and I've got a trust, they put their homestead in it and they lose their homestead exemption. And by the way, when that's discovered 10 years later, they owe a lot in back taxes. That trust should identify family members, successor trustees. It should have good incapacity instructions, personal property distributions and rules, and then AB provisions for married couples. We'll talk about that. Not a lot today, but most married couples need that. Distribution provisions to beneficiaries. And then what I call a Titanic plan if everyone dies. And I tell people it's, if the whole family takes a cruise on the Titanic and none of them get off, what happens then? It should outline trustee powers. I was working with an attorney one time who we got to that section. She said, oh, this just tells you what's in the trust code. And I asked her, do you have a copy of the trust code? And she didn't. I didn't do this in front of the client, but I said, do you think if you don't have it and you're a lawyer, what are the chances a client's going to have that? Don't say that. And we have modified what those powers are, which you can do in the trust in Texas. It also outlines administration rules, and those are not necessarily the same from one trust to the next. The trust can handle incapacity much better than powers of attorney or guardianship. It can actually replace powers of attorney that are prone to failure. Now, we still do powers of attorney, but we count on the trustee being able to do it. Trusts, again, they can avoid guardianship. They can provide instructions for care. And I can't tell you how important That is, it saves a lot of time when you know what needs to be done and the person has said, these are the facility features I want and that kind of thing. The successor trustee, again, has far more authority than an agent under a power of attorney or a guardian under the court supervision.
So up to now, we've kind of backed up, because when we talk about executors, we're talking about death. But we wanted to back up and talk about the fact that there are other roles that are fiduciary roles that counter the role of the trustee. So trustee can serve in and be the counter to all of these other roles. And up to now, we've been talking about incapacity and while the trust maker or the client is alive. Now we're going to move into what we call estate administration, and we're going to talk about what that looks like. What you're looking at in front of you, the estate settlement cost funnel, meaning all the estate pours into this funnel when after the person has died. And where does it go? Well, one of the first places it goes is administrative costs. That's going to be attorney's fees and court fees and different things, depending on which type of administration it is. So depending on that, you are going to have different rules for administering a trust versus going through a probate. How many different sets of rules are you going to have to look at? Where does your family fit in this? They don't fit anywhere in the administrative issues. They don't get paid yet. If you've got a probate, and you could have, if that's what you've got, if you've got a will, you're going to have to probate that will for it to be effective. And so if you're going through a probate, then there's going to be probate cost. And then if there are creditors, there's going to be figuring out how to pay them back, whether they're, there's going to be attorney's fees on whether trying to figure out whether they're valid creditors, those kind of things. So that's more money out the door. Taxes can be an issue. The main one when it comes to estates and after death is the estate tax. If an estate tax return has to be filed, then that's going to increase the cost of administration by a lot. Finally, after those things are paid, whatever's left then can go to the beneficiaries. How assets go to your beneficiaries upon your death is a really important concept to understand, because there's really 4 basic ways that assets pass. First, you've got joint with right of survivorship. And when that happens, like maybe a joint checking account between a husband and wife, it passes to the individual survivors of that account 100%. And it's a very quick transfer. It usually requires a death certificate and not much else. If you've got a beneficiary designation, it is similar. We call that planning by the box, filling out the boxes on the forms with the names of the beneficiaries. Again, that's going to pass directly to an individual beneficiary with death certificate and filling out some forms. That's going to be things like life insurance policies, IRAs, payable on death accounts, those kind of things. Then in both of those situations, you have no control. Once the person has died, there's no control. If there's any issues with the beneficiaries, it's still going to go to the beneficiaries. There's no tax planning in that. If it would have a negative tax impact for any reason, there's no planning around that. It's just going to go directly to the beneficiaries. Third way is if the assets are owned by a trust. At that point, then the assets pass by the trust terms, and those are as various as you can imagine, because within a trust, you can be very creative. And then finally, anything that is left that is owned by the individual person who has passed is going to have to go through probate, either by will, or if they don't have a will, there's something called intestate succession, which is basically the state's default will for you if you don't have a will that you have created. And once that is done, those assets then also go to the beneficiaries, but it takes a lot longer. The assets are they are frozen. No one can do anything with them until that probate is complete. And so, so it's important to recognize these different ways that assets pass. And when it comes to the trust, you can connect these assets to the trust, aligning those assets, having the trust own them. And when you do that, you avoid the guardianship when they're alive, but also the probate after someone has passed. And so that is the way, the more efficient way to get your assets to your beneficiaries. The other thing we need to look at is the different kinds of rules that have to be followed when you have these various ways that assets pass. When it comes to joint with right of survivorship, you've got the Internal Revenue Code, you've got right of survivorship or contract laws. You would be looking at things like the Estates and Probates Code, Property Code, Insurance Code, Family Code, lots of different laws that impact that passing of assets, and same for beneficiary designation. When you've got,
that's in each state where you have an owner, survivor, beneficiary, or where assets are located.
Right. So you've got lots to deal with there, and so you've got to keep all of that in mind. That can make it so much more expensive and time consuming. But with the trust, you've got the Texas Trust Code that will go in with the terms of the trust. And it's much simpler. If you're going through probate, then you've got every state where real property or assets are owned, and you've got to look at their estates code, probate code, property code, and other laws. So when you're an executor or a trustee after death, as we've talked about, that is a fiduciary role. And there's three, and again, you're going to see references to trust through these slides, but it applies to wills and executors too. So just keep that in mind. So there's three categories of just general duties of a trustee or an executor. They've got to handle the assets. They've got to collect the assets, make sure they understand the value, maybe get appraisals done. They're going to have to manage them and invest them until distributions are made or their role is no longer needed, whatever that might be. They're going to have to pay the debts and the expenses and the taxes on the estate, but not without legal counsel, because some of those need to be paid and some of those don't. Remember that they've got a fiduciary duty to the beneficiaries, and so they have to be very, very careful in what they pay and making sure that it is a valid expense. And they need to know that they do not use life insurance proceeds to pay those debts. Then they are also going to be making distributions to the beneficiaries named in the document and according to the terms of the document. It could continue in trust depending on what the trust maker has set up. It could be an outright distribution, could be a testamentary trust that was in the will that would say put it in a trust. So they're going to have to follow the rules of whatever document they've got instructing them. Some of the things that fiduciaries will do after the decedent has passed are things like meeting with having a family meeting with the attorney, making sure that everybody understands the trust and can have their expectations set so that they know the kinds of things that are going to be done through the process. They need to share asset information so that the beneficiaries are well informed. We find that our biggest issue in post-death situations, whether it is probate or trust administration, is always lack of communication to the beneficiary. So they've got to establish a good communication system and then explain insurance on assets that they're still having to pay for. Let everyone have some input on what's going on, although most often they have got the final say. And then knowing which beneficiaries have hired their own attorneys, because the attorney for the executor or the trustee is not the attorney for the beneficiaries. When I represent someone who is a trustee or an executor, my job is to make sure they do their job, which is to be a good fiduciary, but I don't represent the beneficiaries, and I have to make that very clear. So knowing what beneficiaries have hired their own attorneys is important. And then following through and doing what you say you will do is key. As Rex mentioned earlier, documenting is so critical. Recording everything that you do, whether it's the time you spend or the money you spend. Don't throw away anything. Keep all receipts so that you've got the ability to show money that was spent and why. It's really not possible to over document. Email is a great communication way to communicate with people. You just need to make sure that you keep all your emails that you sent and the responses and get read receipts. Then if you ever do have to defend yourself, you just have to keep in mind that the other party has kept everything. And so you should have it all too, so that there's not any missing communications, or you're not surprised, or your attorney's not surprised by something there.
So,
some of the general, did you need to say something, Rex?
sorry, no.
Some of the general rights of beneficiaries, have the right to be notified of major events, including you taking over the estate of their benefactor. They are entitled to receive a copy of the trust or the will. They're entitled to information regarding the trust assets, periodic inventories and accountings for transactions, income and expenses. Unless they've waived that, they are entitled to that. They are also entitled to timely distributions as the trust or the will dictates. So as a fiduciary, before a fiduciary takes any action, don't use assets for your own personal reasons. That will get you in trouble quicker than anything. You can't pay any personal expenses from the trust assets, not even if it's just borrowing it and paying it back. If you're making any distribution to anybody, you've got to make it proportionate to the others. You can't act alone if there are co-trustees or co-executors with you. Everybody has to be involved in those decisions. Other co-trustees or executors would need to co-sign on any consent to your actions. And then there is a way to delegate that signing at a later time. Also, before you take any actions, don't transfer any firearms without legal advice. There are so many ways that you can accidentally commit a felony. Don't ever commingle the estate or trust money with your personal accounts in any way. If you have to, for some reason, deposit income or something into your own account, you transfer it immediately to the estate or trust account, and keep very careful and copious track of the deposits and any earnings that come in. Always respond to reasonable questions and requests of beneficiaries. If you And do it courteously, because that's where where conflicts occur and where you end up with a much bigger problem. And this is where it's frustrating, because successor trustees, after the trust maker has died, it's all on them, and they have to be ready to keep things smooth so that things can get done in an efficient fashion. Don't do anything to create suspicion. If they lose confidence in you, they are going to object, and it will cause fights. Always be responsive and communicative. When someone passes away, there's duties to the IRS. They're going to expect a final individual income tax return, a 1040. To be filed. And then there may be an administrative income tax return, which is a 1041, just from the date of death to the end of the year. There can be some exceptions to that, but a CPA can always give good advice there. And then if a trust is continuing or an estate is continuing after the first of the year after death, there may be a 1041 for that year as well. So those are some things that the IRS is expecting. So as we talked about guardianship before, probate is the equivalent of guardianship after death. And it's a very similar situation. It's a solution to a problem. The problem is that the person that owned the assets has died and they can't sign the necessary documents to transfer the assets. And so the probate solves the problem by having the judge authorize a substitute signature. It is a solution, and sometimes it is the only solution to the problem. But is it the best solution to the problem? Rex?
Well, under the Estates Code, let's define probate. The technical definition means to prove up the will. I prefer the layman's definition, the court-supervised transfer of assets for someone who has died. And one of the problems is if you call a law firm and you say, what does it cost to probate the will? What you really want to know is what does the whole process cost? Not what does it cost to go to court for the first hearing and prove up the will. People want to know how much does it cost? How long does it take? No one who is being honest with you can answer those questions. If you knew, here's what you should ask. Who gets paid first and who controls the process? Well, under Texas law, funeral and last illness up to $15,000 each if the court approves. And when you see things in statutes like if the court approves, the way courts approve things is lawyers go to court and argue them. Courts approving things can be expensive. Family allowance for up to 1 year if you have qualifying family members. Cost of administration, attorney's fees, court costs, executor, preserving, safekeeping, and managing the estate, and unpaid guardianship fees. Secured claims and tax liens, unpaid child support and interest, taxes, penalties, and interest. I see a lot of you cheering out there. Yes, that's the IRS. In Texas, they're number 6 on the list. Isn't that great? Cost of confinement if somebody was in jail or prison, repayment of medical assistance like Medicaid, and then other claims. Won't really talk about it today, but if you have somebody who owns rental property, it may not be possible for the person who's been died to be paid. Even though the renter is willing to pay, who do they write a check to? That can be a problem. Now, did you notice who isn't on the list? It's the family. The family and loved ones are last on the list. But that doesn't tell us the second question. Who controls this process? Well, it's not the courts and it's not the attorney. It's anybody making claims. We never know how many claims will be made, how long it will take to resolve those claims, or how much it will cost to resolve those claims, which is why if somebody tells you probate is going to cost X, just assume they will lie to you about other things too. Now, the first probate I ever had, this was my client. I call him the driller. He was my granddad who was a driller for Mobil Oil. He died while I was in law school. And about 15 months after he died, there was a hailstorm that destroyed the roof on the house. And my grandmother found a roofer, and the guy must have liked her because he said, if you and your husband will sign my contract, I'll come do the work and you can pay me when I'm done. And my grandmother signed and then made a joke about, well, it's kind of hard to get my husband to sign on account of him being dead. And then the guy said, oh, in that case, you're going to have to pay me in advance. Well, that sounded like a really bad idea. The family called and said, why is he being a jerk? And I said, he's not. He can't go get a lien against the house unless every owner signs his contract. Well, how do we get his name off? We've got to probate his will. And they had not even given any thought to doing the probate. Well, his will was done in 1973, but it wasn't self-proved. That meant we were going to have to take witnesses. That process of getting witnesses proved to be rather difficult. The court decided that my grandparents' best friends, they had moved about 150 miles away. Since they didn't want to take a bus and there was no commercial air service, I had a cousin who was going to go pick them up and bring them to Irving, where my grandparents lived. And the court administrator says, well, I hope he has a chauffeur's license. Why is that necessary? Because if they can't drive and they won't take commercial air or bus, a chauffeur has to pick them up. My lazy cousin did not have a chauffeur's license. So I managed to get my next door neighbor who knew my granddad. And I was telling him about this. We were just chatting one day because I rented the house from my parents that I grew up in. So I'd known this guy my whole life. And he said, yeah, I remember your granddad. So as a matter of fact, I just the other day saw a box from the shoes I bought from him. And I was like, is there a receipt in the box? And sure enough, and the receipt was signed within 3 weeks of when my granddad signed a will. So I asked my neighbor, would you go to court and be a witness that that was his signature? And he agreed. And then I got an uncle to go, and we were doing a probate as a muniment of title. Well, then we had a real challenge with the witnesses, and I finally was able to get my neighbor, because when my grandparents moved down here, they only knew family. They didn't know anybody else. So I struggled with that, but then I found that, and by the way, the reason moving 150 miles was significant is the probate court's jurisdiction goes 100 miles from the courthouse or to the state line, whichever is closer, as far as compelling witnesses to come.
Rex, before you, I'm sorry to interrupt your story. Before you move on, will you just explain what a probate as a muniment of title is so they understand this is more of a simple probate, but it's still messy.
It's about as simple of probate procedures you can have. You only have to prove the will valid. You don't have to appoint an executor. It transfers title almost immediately. So we're not talking about a complicated probate here, but does this sound simple? It was anything but. Then I told you about the neighbor's shoes, and then my uncle agreed to go. And in 1993, Texas changed the law. Prior to then, if somebody died without a will, their spouse got half of the community property and their kids got half. Well, they changed that in 93. My granddad died in 92. But if my uncle would go to court and say that will was valid, he was arguing against his own best interest. And the court said they would accept that. Well, the day that we were going to go to a hearing, my uncle forgot and went fishing. The judge was very unhappy because I didn't have both my witnesses there. And he made me start all over and told the court administrator, do not give them an appointment for another 2 months. So as simple as this was, my family was very frustrated with this. And my poor uncle caught all kinds of flack for forgetting. He also caught a whole bunch of fish that day, but it was just a challenge. But when we went to court 2 months later, it went right through. Well, that was my first probate. And I got to tell you, I regretted telling my grandmother how easy this was going to be, because I didn't know about the will not being completely valid. I didn't know about the moving problem and having to take witnesses and, all the stuff that happened. And again, that was a simple probate. Now, I'm going to take a minute to show you my favorite picture ever taken. I'm the good-looking kid on the right. That is my kid brother on the left. You'll notice my granddad and the horse are staring suspiciously at him. Yes, that is a horse in my grandmother's living room. She took this picture with a smile on her face. She carried it in her purse for the rest of her life to prove that they did not spoil their only 2 grandkids, and I think that proves it. Well, he died on June 29th, 1994. Now, that picture, I'm glad I have that picture to show how much my grandparents love me, because I'm going to show you what happened in his probate. He would not let me do a trust for him. Well, while we were there for the funeral, a neighbor that my granddad wanted to sell the farm to offered to buy it. My dad was willing to accept the offer. Now, all we had to do was get through the probate. Once again, we were going to do immuniment of title, so this was going to be very quick. Well, unfortunately, that was a drought year in West Texas, and there was no rain between June the 29th and the Monday before Labor Day. And then the Monday before Labor Day, they got some rain. Unfortunately, and incredibly, for the second time in my family's history, it involved a hailstorm. It wiped out the neighbor's crops, and the bank rejected his loan. And I remember my dad and I saying, well, we know how much, we're willing to accept the offer, all we got to do through probate, what could go wrong? The weather could go wrong. And we got the final probate order in October of '94, but it was too late to sell the farm to that neighbor. And if my granddad had had a trust, he would have already had it purchased before Labor Day. That same neighbor bought the house in March of 2007, 12 and a half years later. And we jokingly referred to the farm during that time as the family albatross. And my dad, about this case, he said to me, you lied to me about the cost of probate. And I said, Dad, most people don't have a son who could do the probate paperwork. My granddad's attorney went to court and charged my dad only $250 plus filing fees. And my dad informed me that was not the cost of probate. That part cost less than $1,000. But then he told me if we had had the money before Labor Day of 1994, 12 and a half years later, that money, according to his other investments, would have grown over $400,000 more than we sold for that farm for. Now, my dad said the real cost of probate in this case was over $400,000. It's an opportunity cost, not the actual cost. And after that, I started telling people, you need to think about that. Texas probate is quick, pretty easy and simple. We got through probate in about 3.5 months. It's hard to do it much faster than that. But look at how difficult it wound up being. Now, another family story I'm going to tell you is my mother-in-law's story. I had the most wonderful parents-in-law and in-laws. But after she died, despite one son-in-law who offered to do a trust and pay a North Carolina attorney to do the supporting documents there, my mother-in-law died with a 3-page will. Now, I will tell you about my in-laws. My first experience with them really was going there Thanksgiving and meeting my future brother and sister-in-law and their spouses, spending time with their family. It was delightful spending time with them. We loved doing Christmas with them. It was just very peaceful. We had a lot of fun together. Well, after she died with this 3-page will, there was so little to the will, the family and the attorney had to fill in the blanks. Guess what? They didn't all fill in the blanks the same way. Probate was more difficult than the family imagined. It took longer. And they rented out the townhouse, which my parents-in-law still owed on, and they had to rent it out for years. My brother-in-law did not get enough rent for it. I mean, he did the best he knew how to do, despite the fact that he had somebody who actually knew something about it and never really asked me. And stress over all of this so damaged the family relationships. They had been great up until my mother-in-law died, we were planning 15 months after her death in 2010, in March, the three families were going to get together and go on a week's vacation together. We are still waiting for that vacation. Now, my definition of probate is it's a lawsuit that you file against yourself at your own expense to protect your disgruntled heirs, your creditors, and your future lawsuit creditors. And when I've talked to people about who do you want to protect, never one time have they mentioned any of those people. And just remember, assets in a trust would have avoided that. Now, after death, trusts are owned or controlled by the trust. Those avoid probate. They have distribution instructions for all the assets. They're faster and easier access. Susan went through the 4 ways to access assets, but seriously, you can control the trust faster than you can control any other method of getting assets. And every now and then, we'll have a client tell us, yeah, we left one bank account out of the trust. And I'll ask them, why? Do you not like your family? Why do you want to delay their getting the money? And they always say something like, well, we wanted to have access. You got access to the trust assets. It's faster and easier to administer. There's fewer complex rules than right of survivorship, beneficiary designations, and probate. And it involves only one state's law. And it provides more certainty of result than any other set of distribution rules. Now, after the driller died, my grandmother realized what a nightmare that probate was, and the family said she needs to do a trust. They didn't want to go through probate again. They didn't enjoy it the first time. And remember, that was an easy probate. My family did not think it was easy. So we prepared a trust for her. She was incapacitated for several years, no guardianship. She named all 4 kids and my dad as co-trustees. And frankly, they got along really well. It worked well. She died on September 30th, 2002. Little over 10 years, 10 and a half years after my granddad. Well, the trust was completely administered by the end of 2002. 3 months, less than 3 months actually. So that trust admin went really quick. We didn't have any disputes in the family, and our experiences with trusts, you usually don't have disputes. Now, my mom's story, my dad died in August of 2011. And my mom went through 2 years of various struggles. I won't go into them. But then on August the 6th, 2013, and you want to write this down, this is on the test at the end, Mom called my brother and I and announced to us that she wanted to move to a facility in San Antonio. She lived in Irving, where I grew up, but she wanted to be in an independent living facility in San Antonio by the end of the month. Wow. Don't give us any tall orders, Mom. My brother called and said, there is no way this is going to happen by the end of the month. There's a ton of these places out there, and I've got to go around to every one of them, find out what they offer, present them to Mom, have her come down, look at the most promising ones. And when my brother finally took a breath, I stopped him and said, you don't have to do any of that. In Mom's trust, she's told us what kind of facility features she wants. I'll send you the checklist. Get on the internet and find out what's available. It took him 20 minutes to find 2 places within 10 minutes of his house that met all of Mom's criteria. And she actually moved on August 29th, 2013, 3 weeks and 2 days after that call. And once that happened to my mom, I realized the power of having those kind of instructions in the trust. Then I got the fun job of cleaning out the house. which, by the way, there had been a train wreck in there and it got hit by a tornado. I'm pretty sure that's how it got so messy. We did an estate sale. I had to arrange for repairs. I put it on the market, and we closed on the sale with only my signature. Now, most of the time they would have wanted mom's signature and my brother's signature. We didn't have to do any of that. I completely handled everything that had to be done in Irving, and instructions put in years before made this job as easy as it could have been. In San Antonio, my brother managed her facility care, managed her personal care appointments, doctor appointments, and for 6 to 8 months, she was competent to manage assets, even though she didn't have to. We handled everything. When she became incapacitated, no financial institution knew it because they were used to dealing with my brother and I at that point. She lived about 20 months. She died actually on Mother's Day. It's kind of a day I'll never forget, in May of 2015. And we had the administration completed by December 31st, so we had no 1041 carryover to the next year. I always recommend that people die early enough in the year that you can get it finished by the end of the year. We have some clients who won't do that. I don't know why, but anyway. We divided the personal assets without any issues. And we have provisions in our trust to resolve disputes, but they were not involved on either side of my family. They were completely unnecessary. I arranged the funeral. My mom did not plan her own funeral. I tried to talk her into it, and every time I would go over to do it, my mom would say, "Oh, honey, I have something else I need you to do. Let's do it next time." Next time never came. So my mom got the funeral that I thought would be nice for her. Nobody complained, not even her. So, you know, I guess I did okay. And the inheritances were put in trust for us throughout this process. And then we had the final tax return due in 2016. Now, as a fiduciary, you may be wondering, what in the world am I getting myself into? This sounds like a lot of responsibility, and it is. But you may ask, who would ever want to do this? Well, no matter what kind of fiduciary you are, you're getting into this. And it can be intimidating. There's a lot of responsibilities, and you're personally liable for things. And the possible liability can seem overwhelming. But keep in mind, you can hire professionals, attorneys, CPAs, financial advisors to assist you in the process. And professionals are paid reasonable fees from trust assets. And professionals can make the process a lot easier for you. Consult the attorney first because they're going to know the law, and you may be entitled to compensation as a trustee. Typically, the trustees and agents and executors are paid out of the trust estates. The trust document can tell you about the compensation, how to define income, the amount of the trustee's fee, when it's paid, and we offer free initial consultation with the successor trustees. And I've got about 2 minutes to answer questions before
I can stick around.
So, yeah.
Sheila?
Do we have any questions, Sheila?
I'm here. I had to, Tom, our Medicaid attorney, Tom Ford, has been answering someone's question that it deals with Medicaid. Yes, we have many questions. First, and I'm going to go to them in the order that I saw them. How come it's not going to the first one? Oh, it is. Okay. Karen says, if your loved one can no longer sign documents, how do you create a trust? Does that person have to sign, or can a spouse create it individually for the family? Can a special needs trust be made inside it or as a standalone trust? My parents had a special needs trust for my brother, but it was attached to theirs for the family.
Susan, you want to take a shot at that?
No, you only have a couple minutes. You go right ahead.
That sounds to me like if they have no documents and they're incapacitated, you're looking at a guardianship to get that done. Courts may approve doing a trust. It depends on the court.
Yeah. And special needs trusts can easily be done within a trust or separately, whatever seems to work depending on the needs.
Okay, now the first question here then is from Melissa. She wants to know, can the fiduciary sub out the job?
They may be able to hire somebody to do the job, but they're still responsible.
Yeah. So they can hire the professionals and those kind of things to do parts of things, but they're never going to get rid of their fiduciary duty.
Yeah, so you better hire somebody who knows what they're doing.
Yeah.
Okay, Judith asked, knowing some laws are state-based, do most states have a similar 12 steps associated with guardianship?
I don't know how to answer that because I'm not really familiar with it in every state, but we talk to attorneys all over the country. Guardianships are not easy anywhere. I've never talked to anybody who said, oh yeah, they're easy to do here.
Okay. Samantha asked, could the trust have been used to pay for personal care assistance to help Carl stay in his home?
Absolutely.
Yes.
Boy, these are going well. Okay. Okay. Now back to the. If I live in Texas and have a trust drawn up and then move to Washington State and live with the persons named in the trust, daughter and son-in-law, will Washington honor the trust?
Yes, trusts are valid anywhere in the United States. The challenge with moving them to another state is they're going to be interpreted. For example, if you have a Texas trust, Texas law is going to apply to it. That may create some quirks in another state. And I mentioned one when they're coming to Texas, the homestead law. So yes, they're valid, but you need to have them reviewed by an attorney there. Susan, at this point, I need to get off and get on my other one. So
Okay.
I'm going to
Thank
go to
you,
the next
Rex.
slide. Y'all keep answering questions.
Okay.
Thank you, Rex.
Okay, this one, I'm going to read what it says, but I don't know. Can you please state the lose of homestead exemption? I think it means loss of homestead exemption.
Yeah, so there's just particular language when you put a homestead in a trust. That language has to be present. I don't have it verbatim in my mind, but if that language is not present in the trust, then it's not what's called a qualifying trust. Rex, you're going to need to stop sharing your screen.
Oh, sorry.
I will have to, I think I have to give you permission real quick, Susan. Hold on. Are you trying to share the slides?
No, I'm not. I don't have it pulled up.
Oh,
You might need to pull up the CEU slide at the end.
I will do that.
Rex is moving to his other
Yes.
webinar. So Rex, turn off your camera and mute yourself. This is what happens when we have back to back.
That's all right. We'll get it. Here.
That's all right. So
Next, you're going to tell me to shut up too. So.
I was trying to be nice. There we go. So
I removed you.
So we the homestead rules are specific to Texas, and that's why it's important to have that language in the trust. But it's just particular language that makes it a qualifying trust so that the trust doesn't become an owner in a way that knocks out your ability to have the homestead exemption. I know that's not clear. It's not a quick answer, but.
Okay, next. What happens if no one is willing to pay for the probate? Now, that's a good question.
Yeah, it's tough. It depends on the attorney you're working with. If there are assets, the probate is paid for by the assets in the estate. Oftentimes, because of the nature of probate, those assets aren't available. So what we find that happens most often is someone in the family, a lot of times it's the executor, named executor, will front the money, but that's an administrative cost. And if you remember that list we went through, it's right at the top, right behind medical issues, medical expenses. And so it gets paid back out of the estate. So oftentimes we don't have that issue. Sometimes we have a situation where no one has the money, and just depending on the attorney that you're working with, they may be willing to wait and take the money out of the proceeds once the estate is available. But the estate is actually who is responsible. And if there's not enough money in the estate to pay for the probate, then the probate is probably not worth it. And that's an evaluation that the probate attorney would go through.
Lewis asked, estate taxes, do you mean federal or state or both?
So Texas does not have an estate tax. So when we're talking about it, and I do want to say this because Marty mentioned this at the very beginning, if you're tuning in from some other state, everything we're saying, you just need to assume it's Texas law and nowhere else. I don't want you to think that it's the same everywhere. But in Texas, we don't have an estate tax, but we do obviously have to deal with the federal estate tax. And that does not affect a whole lot of people because right now, the exemption is $12.92 or $93 million per person before you owe an estate tax. And there's just not that many people that have that kind of estate. But if you do, tax planning is really critical because the estate tax is 40%, I believe, of the assets over the amount. So it's a high tax rate, and you definitely want to have tax planning if you fall in that category.
Okay, the next one is also difficult. So in JROS.
Joint with right of survivorship.
Oh, thank you. And beneficiary situations, does the person on the receiving end then pay taxes according to their normal tax bracket?
So there are no inheritance taxes beyond the estate tax that I just mentioned. So when you inherit assets, you don't pay taxes on any of it. Now, the exception to that is going to be IRAs. When you're a beneficiary on an IRA, a traditional IRA, the income taxes have not been paid on that money. And so whoever takes out those assets out of the IRA is going to pay the income tax rate of their own income tax rate on that as income to them. But otherwise, anything you inherit is yours. And in fact, one of the benefits of inheriting assets is you get a step up in basis. And so meaning that if your parents bought a home in 1970 for $90,000 and they died last year and it was worth $500,000, you get the value when that second parent dies, you get the value at the time they passed as your basis. And so if you turn around and sell it for $500,000, there's no capital gains there. So that's a benefit of inheriting assets, is that step up in basis so that the beneficiary doesn't even pay capital gains unless they hold on to it and it increases in value after that.
Okay. Jessica and Suzette's question, Tom has been answering. So because it deals with Medicaid.
Okay.
Of the three types of trusts, is there one you recommend over another?
I am not sure what three types of trusts they're referring to, but I will just tell you there are many, many types of trusts. You in many ways to customize trusts, so there's not a simple answer to that. The other part of that answer is there's no way to recommend a type of trust until the assets and the family situation are known. So that's a very customized individual answer. Sorry, I can't really answer it. A living trust, I will say a living trust that you create while you're alive is, in my mind, preferable to what's called a testamentary trust that is in a will. Because if you've got a living trust, you've set it up. You've got the assets in it while you're alive. And when you pass, that is so much easier on the people that come after you to deal with it. If you had a will and then you said in that will, I want everything to go in a trust, that's a testamentary trust. It's not set up yet. And so they've got to gather the assets, get them in the trust, get it set up, and then figure out if it's going to work or not. Where with a living trust, you've worked on it, you've used it, you know it works when you pass. So between those two types, I prefer a living trust over a testamentary trust.
Okay. Can homeowners add another person who will inherit the home via the trust to the homeowner's documents with the county to ensure transfer of the home after death?
That's really combining two options. There are some types of deeds that you can do that are transfer on death, so that when you die, it goes to a beneficiary. And there's a couple of different options there. But that is like a transfer or a pay on death account that we talked about earlier. You've still got those same issues. If there's issues with the beneficiary, you can end up with guardianship, those kind of things, but you can't avoid probate that way. But if you're talking about the combining it with a trust situation, then all you need is a special warranty deed, transferring it to the trust. And then the trust says where it goes from there. And the trustee, who is the title owner of that asset, and so the successor trustee becomes the title owner when the initial trustee passes. The successor trustee is the one that can sign the documents to transfer it where it needs to go. The county doesn't have to recognize anything. They acknowledge that it's owned by the trustee of the trust. And so then wherever the trustee says it needs to go, that's where it's going to go with another transfer deed.
Okay. How does a pour over will factor into this process? Does it need to be probated so missed assets are properly transferred to the trust?
The short answer to that is yes. The fact that you know what a pour over will is something. So in any trust plan, you always have those other supporting documents like those powers of attorneys and all those things. Included in that is a pour over will. And it's called a pour over will because if there is an asset that is not owned by the trust and a probate has to be done for that asset, the will says put it in the trust. So it's called a pour over will because any assets that have to go through probate are poured over into the trust. And then the trust determines how the assets are distributed. That's why we encourage our clients in 15 different ways to get their assets aligned with the trust while they are alive, because that's the only way to avoid the probate. We've had people that did a trust and beautiful job with the trust, but didn't take the time to then get their assets aligned. Some of it we do. We take care of things like deeds for real property. We do that in the process of your planning and your document preparation. But other things we can't do. If I called the bank and said, you know, I've got John Smith here, he's my client and he has a bank account with you and I need you to change the name on that bank account. They would say, who are you and why do you get to tell us what to do with his money? They won't listen to us. So there's parts of it that you have to do the legwork yourself. And if you don't take the time to do that, then your family's going to go through probate to get it done when you're gone. So it's much better process if you're doing it while you're alive and well and know all the banks and everywhere to go. But yes, if there are assets left out of the trust, the pour over will is what will take care of it. It will have to be probated for that to happen.
Is a designation of guardianship still recognized in court if completed prior to a person's incapacity?
Yes. So a declaration of guardian is a document that we always provide in our packages. That is a very great thing to have if a person becomes incapacitated. And I've actually served as an attorney ad litem for someone who had a declaration of guardian. Now, it is not the final say, but it makes it very easy on the attorney ad litem to agree to what this person who this person chose while they had capacity. And so then the attorney ad litem feels very comfortable in going along with that unless there's evidence to show otherwise. And then it also, the court has to defer to it as long as there's not any evidence to show that this person is not qualified in some way. So yes, it is definitely something that is recognized in court, but I don't want you to, it doesn't avoid guardianship. It just helps the process along.
Will a trust attorney take a person through all the different categories and instructions of things to include the documents which results in the no super difficult circumstances that presenter experienced with mother and another family member?
Yes. So a good estate planning attorney will walk you through all the options that will work for you. And I always tell my clients that my job is to get them peace of mind. So once I've educated them on issues they might not have realized were there, like for instance, one issue that is very compelling is having a blended family. If you don't have a good plan with a blended family, I can promise you your assets are not going to go where you think they would go. And so, walking through those specific issues, and then a good estate planning attorney will turn around and say, okay, then with your situation, these are the options to satisfy the things you are concerned about. And some of that peace of mind is price of the plan. And so we want always to plan toward you having peace of mind, or the client having peace of mind about what they've done, how much they've spent, and what it looks like when they've finished it.
Sheila, real quick, did you get a chance to go over the CEU the second time? I may have missed it, but that's just because it's
Sure,
11:30.
yeah.
If we could go over that, and then if you want to stay and ask questions, I just don't want the people that have to get off.
I agree.
not.
Absolutely.
Okay,
Go ahead.
as soon as we're done here, I will send Marty the 3 documents are in regard to this CEU. One is a disclaimer, which tells you that we do this for a living. Heyman Hogue does this for a living. However, this is strictly an educational program for you, so that you understand that. The other 2, however, I will need you to fill out and return back to me, which are an eval of the program and the presenters, and a sign-in sheet, so that I can issue your certificates.
Great. So if you'll sign those documents, print them off, sign them, take a picture of them, or scan them back in and get them to Sheila, that would be great. But in addition to that, we have a Google survey that should pop up as you close out of Zoom today. If not, you'll also be receiving that link in the follow-up email. And that survey is really to help us collect information to report back on the goals and objectives we set forth when we applied for the funding to do this. I just want to make sure we had a chance to go over that for anybody that got on late. But I'm going to turn it back over to you guys for Q&A, and as long as you guys are interested in doing that.
Yeah, let's keep going.
Okay, Lewis wants to know, are there any assets you should not put in a trust?
Broad stroke answer. The only real exception for our clients is we'll tell them they don't need to put their cars in the trust. It's not that you shouldn't. It's just not necessary, as long as your natural heirs are easily identifiable and can sign off on an affidavit after you're gone. They're able to transfer the car without it going through probate. Otherwise, you cannot put an IRA in the trust. It can't be owned by anybody other than an individual, but there are ways to deal with IRAs and align them with the trust as well. Otherwise, pretty much everything else should go into the trust. That is going to make for the smoothest process when you're gone, or if you're incapacitated.
Because Karen, further down, says life insurance is best to go to a person, not the trust.
So that's actually not the case. I would like to know why she feels that way, but my experience has been, if the insurance policy is owned by the trust, then that means the trustee can manage it, even if the owner of the policy or the person who set it up to start with is still alive. And if it needs to be cashed out or something like that, they've got the ability to do that because the trust owns it. But then the trust being the beneficiary, it doesn't have any downside that I'm aware of, but it allows also, if the beneficiary, I'll say a husband and wife are in a car accident, one dies, life insurance policy, the other one is incapacitated. The last thing you want is to have a guardianship over that surviving spouse because the life insurance went directly to them. I don't know a downside to putting it in the trust. We always recommend that the trust be the beneficiary of the life insurance policies, and then it goes according to the terms of the trust.
Since Texas is a community property state, should anything listed to a beneficiary be labeled as a gift in the event of divorce? And actually, he's talking about a home that is already in a trust.
I am not sure I'm understanding that question.
I guess because he answered that right after that. So Alan, if you could type something else, because he can't, that, I don't know. I'm just saying, since Texas is a community property state, should anything listed to a beneficiary be labeled as a gift in the event of divorce? And then
a gift, just so you know, a gift, like from one spouse to the other, a gift is separate property. Doesn't matter where it came from. So if you gifted something to a spouse, I don't know whose divorce we might be talking about. If we're talking about the divorce of the kids, there are ways to set up the trust so that it is not accessible to their spouse, divorce or not. And there is divorce protection that can be done within the trust documents. So if that's what you're talking about, yes, that it's not a gift. You don't label it as a gift, but there are ways to protect against the divorce of your beneficiaries. Assuming that's what you're talking about, that's an easy answer. If you're talking about your spouse, it's a little bit, I'm not sure I could make sense out of that. So okay. I'm assuming you're talking about your kids.
And Karen, back to the life insurance, says she put that because her mom had to take all of the life insurance, I guess, in 5 years, whether she needed it or not, and was taxed on it. If it had been, okay, sorry.
That had to have been, sorry, I'm sorry to interrupt, Sheila, but I don't know where we're going with that. It's an IRA. It was probably an IRA. It might have been in the form of an annuity, but that's the 5-year rule. It affects qualified annuities, which often look like life insurance policies, but they are not. They are qualified annuities based on and funded with money that was never taxed. And so they are treated like an IRA. And that's what you're talking about. And so in the sense of an IRA, any kind of qualified account, that is true. Putting it in the living trust cuts down on your time to be able to pay the taxes on it and pay it out. And so that, now I'm following you, a flat out insurance policy that there are no taxes on the insurance policy, but a qualified annuity or an IRA, there are. And there are ways to plan with trusts. Specifically a retirement plan trust where you can keep the 10 years, but it's not a normal living trust. It's different. So now I know, yeah, that makes sense to me.
Okay. Does a payable on death designation on any bank accounts, checking, savings, or CDs supersede any trust instructions?
Yep. That's why you don't, because that's a contract and it's a more specific contract than the trust. And so that's why we want the trust to own the asset and be, if there's a required beneficiary, in those cases, there wouldn't be a required beneficiary. If it owns it, it's in the trust. But if there's a beneficiary requirement, make the trust the beneficiary. That way your estate plan is followed with all of your assets. When you start parsing it out and deciding, well, I want to make this one a payable on death, you still have that issue of what's going on with the beneficiary when you die. And if they're incapacitated or going through a divorce or having creditor issues, they could end up losing their inheritance because of the way you did that. So.
Okay. And the last one that I see here is, what is the minimum estate amount that would be worth spending the money it costs for a trust?
That is similar to a question we had earlier. Impossible to know. I mean, that's one of the reasons when we do estate planning, we do free consultations, because people don't know what they should spend until they have had some advice from an attorney. And so there's really not a minimum. It's what gives you peace of mind to deal with the issues you're worried about while not spending more money than you're comfortable with. And that's a fine balance that really is individual in every situation.
Well,
And I
actually,
think one more
yes,
question from an attorney popped
I
up.
see that. And I see that. I am a housing attorney, but I don't do a lot of probate work. I have a client who wants to leave her house to her adult son who has mental health issues.
Mm.
She is concerned that he will sell the house after she passes. What's the best way to transfer the property? A will or a testamentary trust? Which do you know?
In that situation, I would want her to set up a special needs trust for him, and have someone else managing the asset. If that's a real concern that he just doesn't have the capacity to manage assets, then he probably wouldn't be able to manage the sale or the maintenance of that home. And so my recommendation would be, if she doesn't set up a special needs trust while she's alive, that she have a trust plan that includes a special needs trust in it, so that that's where it goes when he passes.
And that is our topic for next month. Our topic for next month will be a special needs trust. Just
Yes.
to caveat off that. Thank you.
Yep.
We're working on a date now, folks.
Does that get us taken care of? Everybody good?
That's all I saw.
I think so. Susan and Rex, please pass it on to Rex. Thank you so very much. As always, just truly impressive.
And Tom for answering the Medicaid.
Absolutely. Thank you, Tom, for chipping in.
Thank you. Sheila, thank you so much. Thank you very much. We are going to do our next month's presentation. We're working on the date. It will be on special needs trust. So join us for that, please. And thanks again, y'all. And thanks for everybody for joining us. And y'all have a wonderful day.
Y'all take care.
Take care. Bye-bye.